Legal Voice who's joining us. Satish Maneshinde is a senior lawyer with the Bombay High Court. He's now joining us. Mr. Maneshinde, what the court essentially has said is while the actions of the Speaker and the Governor may have been bona fide erroneous, but the status quo ante cannot be restored because Mr. Thackeray chose to resign and not take the floor test. So net-net, nothing really changes. While you can argue constitutional morality and otherwise, but politically or legally, the current government continues.
Well, what actually happened was very unfortunate in the sense that the electorate elected the BJP and the Shiv Sena together. And Uddhav Thackeray walking away from the alliance was itself a stab in the back of the electorate. And I think ultimately the just deserts have been served in the sense that in spite of the fact that he was sitting in the Chief Minister's chair, and the governor had asked him to prove his majority, whether rightly or wrongly, he chose to resign and leave the field voluntarily. It's like walking away from the boxing match. And he left no option for the Supreme Court to pass an order that was passed today, because the Supreme Court, if you remember, at the very initial stage, had said that how do you expect us to put you back in the saddle once having voluntarily resigned? And nobody asked him to resign at that time. And if you have seen Mr. Sharad Pawar's book, which has been recently released, I mean, even Mr. Sharad Pawar, who is the most seasoned politician of Maharashtra today, has said that his resignation left him in bad taste, and it was a totally uncalculated move that he took independently, and it totally showed immaturity on his part. First of all, he showed his immaturity in the sense that he did not even know that 16 of his MLAs who were provided with the security which Maharashtra government had offered those MLAs, left quietly and walked away to Surat in whatever manner. And he showed his inept handling of the situation in the sense that he did not even have the maturity to keep his flock together.
But Mr. Maneshinde, hasn't the court also today, in a sense, rapped on the knuckles both the Speaker for his actions, saying that his appointment of the whip or his recognition of the whip was illegal, Mr. Gungale, the new whip who was appointed, and two, also the governor saying that the governor had no business asking for a floor test because this was an intra-party dispute and there was no material evidence to show that Mr. Thackeray had lost the confidence of a majority of his MLAs.
Well, the Supreme Court may have said whatever it has said today, but the governor, being in a tight situation during that time, was left with no option but to ask for the floor test, because in Bommai's case, the Supreme Court has always said the real test of strength of the Chief Minister is on the floor of the Assembly. And he did not want to see those people who are being paraded before him or the list furnished to him. So he asked him to prove his majority. Rightly or wrongly, he took a decision. In posterity, if the decision has been held to be wrong, then the next legal course will take charge.
But Mr. Maneshinde, has this now set a precedent for governors that if there is an intra-party dispute, unless the MLAs explicitly say they are withdrawing support, and more than two-thirds of them say they are withdrawing support, there is no mechanism of a floor test, or it's not the business of the Speaker or the Governor to decide the strength of a legislature party?
See, there have been conflicting opinions. In Bommai's case, the Supreme Court said that the real test of a Chief Minister is on the floor of the Assembly. Now we have a judgment of this nature. Ultimately, the matter has been referred to a larger bench. And I think the larger bench will decide what should actually prevail.
Okay, Mr. Satish Maneshinde, we'll leave it at that. We'll see how this story plays out. But it is an important